Have you heard of something called a Psychiatric Advance Directive and wonder if it might be something that you or your loved one might want to know more about, especially in planning ahead for psychiatric crises before they happen? Hi, my name is Betty Rowland. I'm a consultant with NAMI North Carolina and a member of NAMI for many years. The National Alliance on Mental Illness is a grassroots organization providing support, education, advocacy, and public awareness so that all affected by mental illness can build better lives. As you know, a Psychiatric Advance Directive, or PAD for short, is a legal document that allows you as a person with lived mental health experience to give consent for or to decline specific future psychiatric treatment. This empowers you to plan ahead for crises and offers you an opportunity to state your preferences for treatment, even if you're not able to communicate them at the time. You can also choose to authorize a healthcare agent or healthcare power of attorney to make decisions about treatment on your behalf based on your stated preferences. This video answers a frequently asked question about how PADs compare to guardianship, how they are alike, and how they're different. Guardianship is a decision made in court by a judge that an individual meets the legal definition of incompetence. Once that adjudication is made, a guardian is appointed. The guardian has the legal authority and the corresponding duty to care for the personal and property interests of another person, including making healthcare decisions about treatment. The guardian makes decisions on behalf of their ward based on their understanding about what would be in their ward's best interest. Any change in the status of guardianship would require a petition to the court requesting a judicial review. A Psychiatric Advance Directive allows an individual, when they are of sound mind, to create a legal document which hospitals and treatment providers are required to consider that states your own preferences for treatment and gives informed consent in advance for things like hospital admission, for agreed upon medications, and so on. The decision about activating a PAD is made by the admitting or treating psychiatrist or other authorized medical provider, not a judge. A PAD only goes into effect when the individual is considered incapable. Incapable means, in the opinion of a physician or eligible psychologist, the person currently lacks sufficient understanding or capacity to make and communicate mental health treatment decisions. The PAD is deactivated when the physician or eligible psychologist assesses that the individual has regained capacity to make and communicate treatment decisions and then give true informed consent. In summary, PADs are generally implemented in a relatively short-term way, only until the person regains their capacity, with the decision to activate and deactivate the PAD being made by a treatment provider. Guardianship is generally a longer-term judgment of incompetence, covering more areas of life, including financial, with the decision to restore competence being made by a judge using the court system. Because the terms incompetent and incapable are so similar and yet are different legal and treatment terms, this sometimes adds to the confusion requirements and decision pathways between a PAD and guardianship. If your family member already has guardianship established, then generally there's not any additional legal advantage to having a PAD. If you or your loved one would like additional information on this issue, you may wish to consult your own attorney or go to the NAMI North Carolina website for links to more resources which may assist you.